A very warm welcome to all the viewers. I am Advocate Anshuman Singh, and in this segment of the interview, we would be speaking on the NRC, the National Register of Citizenship. And to answer my questions, I have Honorable Justice Iqbal Ahmed Ansari, formerly the Chief Justice of the Patna High Court and currently serving as the Chairman of the Punjab State Human Rights Commission. Honorable Justice Ansari, it is such a pleasure having you here.
Thank you.
The Government of India, as back as on the August of 31st, 2019, has released the final list for the state of Assam, wherein 19 lakh people have been excluded from the list. My very first question to you, Justice Ansari, is that do you feel, and this is an unequivocal question that I ask you, is whether the criteria adopted for updating the NRC is dehors the statutory provisions of law, because clearly the NRC, which is under the NRC rules, sets the cutoff date on the 24th of March 1971, while the Indian Citizenship Act, which is the statutory law of the land, sets the citizenship eligibility cutoff to be on the 1st of July 1987. Justice Ansari, how do you see this contradiction?
This conflict between the preparation of NRC and the Citizenship Act makes it obvious that once there is a conflict between the two, it is the statutory provisions which would prevail. So, as of today, it is the cutoff date for the purpose of considering as to whether a person is or is not an Indian citizen would be 1st of
July 1987.
And obviously, therefore, the preparation of the NRC on the basis of cutoff date as 24th of March 1971 would be clearly illegal. Tomorrow, if the Supreme Court interferes with the Citizenship Act as amended in 1985 and 87, then matter is different.
And therefore, let me reiterate, because this is a very, very relevant point to start with. You are saying, Justice Ansari, that the NRC process basing itself on the cutoff criteria is completely contrary to the unequivocal law of the land, which is the Indian Citizenship Act 1955.
See, today, if you declare anyone as a non-Indian or a foreigner, what will happen to him? Because he may still be covered by the 1987 amendment, or 1985 amendment. So, the preparation of the NRC on the basis of executive instruction, let us clearly bear in mind, will not prevail over the statutory provisions.
And therefore, the executive instructions that have been issued is completely contrary to the section 31A of the Citizenship Act that talks of citizenship by birth. I come to the next question, Justice Ansari, and this question is really on the position that the Honorable Supreme Court of India has been taking. On the 9th of August, if I may so remember, it had categorically said that no citizenship would be denied to any individual on the basis of birth. However, the NRC list clearly violates this. But subsequently, the Supreme Court on the 13th of August said that since the NRC process has already been initiated, it may not be possible to reinstate the process all over again, therefore giving a precedence and priority to perhaps convenience. How do you see this contradiction by the Honorable Supreme Court of India?
The Supreme Court is the highest court of the land. Its decision, the law declared by it, is binding on all the courts, all the citizens. So, there is no question of Supreme Court going for any kind of convenience. Once the Chief Justice of India had already made it very clear that no Indian citizen would be excluded from NRC, how then after a few days Chief Justice of India says that since this process has already been taken, we would not like to wind it up now. I feel horrified because that cannot be stand of any court of law and more so of the Supreme Court of India. Because what will happen tomorrow if the Citizenship Act is upheld? Then all this exercise which we have undertaken, so much of cost which has been involved, not only of the government but of the people, what will happen to them, what will happen to the suffering?
And since Justice Ansari, we are on the positions that has been taken by the Honorable Supreme Court of India, I take you back to now the Sonowal's judgment, wherein the IMDT was struck down. Do you feel that that was the starting point wherein the apex court itself exceeded its jurisdiction?
I will not say it was the starting point, but yes, it was an important point in the sense that the question of NRC had arisen long before Sonowal had filed the case. He had challenged thereby that illegal migrants determination tribunal, which is known as IMDT Act. Now, Supreme Court was required to decide in that particular case whether the Parliament had the jurisdiction to legislate, was any of the provision made under the IMDT Act in conflict with any law, particularly with the fundamental rights or any constitutional provision. It did not. What it did was it went by the report of the then Governor of Assam, Lieutenant General S.K. Sinha. Lieutenant General S.K. Sinha gave the information so many lakhs of Bangladeshis have come to India. A governor's report is not an affidavit. You can't proceed on the basis of a governor's report treating as if it is the Bible. It cannot be. So the Supreme Court took the view in this that no, this amounts to external aggression. So almost it was a case of emergency, and the Supreme Court having struck down, the Government of India had to proceed with the process of NRC. I have no objection, personally speaking, against the preparation of a register of a national register rather of citizenship, because that will give the government and the people of India a clear picture as to how many Indian citizens live in India. But it has to be ensured that not even a single Indian citizen is excluded from that list of citizenship. And that would be the Government of India's responsibility. But unfortunately, Government of India's responsibility is being discharged by the Supreme Court of India. Government of India repeatedly asked for time, Government of Assam repeatedly asked for time, but the Supreme Court was fixing a deadline. Why the deadline? When there is a human cost involved, human life is involved, and the particular cutoff date, whether it is here or there, it makes no difference. Why should I cause harm to any human life by my what you call the haste?
And therefore, Justice Ansari, while you're not questioning really the objective and rationale behind the updation of the NRC, what you're certainly questioning is the process that has been undertaken to implement the updation of NRC and whether that faces the test of rationality and reasonableness.
I would also add that the Supreme Court has decided what are the documents which would be taken into consideration for the purpose of determining a person's citizenship. From where has the Supreme Court got the power, I still wonder. Because it is basically for law to decide what documents will be taken if the law wants to. Otherwise, when an accusation has been made that I am a foreigner, then in that event the burden of proof lies on me, and what evidence I will give is for me to decide, not by anybody else, not even by the court, what evidence I will give.
Therefore, coming to the process specifically, while what you say, Justice Ansari, is on the arbitrariness of the burden of proof on the accused himself to prove his citizenship, what is also arbitrary is the documents and the exact types of documents required by the authorities. One, the pre-1970 legacy documents, and the other, the post-1970 documents, which may not be readily available by the people who have been asked to prove their citizenship?
You see, as far as Assam is concerned, we have to bear in mind that there are at least 2 to 3 floods everywhere. And once there is a flood, villages after villages, they just float. The migration took place from one place to another. Now, at the time when you are facing threat to your life, you will not be looking for documents to be saved. Because if we now say that these documents are as important as your life, then in that event I will have to sleep every day with this document tied to my chest, which is not and cannot be done. So, it is possible for a person when he says that no, I have lost the document, that yes, he might have lost it. But insisting that no, now you must prove where is that document, where is that lead, it will be very difficult.
And the arbitrariness, really, so to speak, doesn't end here. Even in terms of the issuance of notices, as have been made to understand, no grounds have been disclosed in the notice.
This is another startling and baffling thing to be done, particularly when the exercise is being monitored by the Supreme Court. Under the law, you will have to state the main grounds on the basis of which one is accused to be not an Indian citizen. Obviously, if I am being told that you are not an Indian citizen, I will have to be told why am I being regarded as not an Indian citizen but a foreigner. So, if this reason are not assigned to me, how will I reply? And how will I reply effectively?
Let us now really move on and come to the consequence of the list that has been declared on the August of 31st, 2019, wherein 1.9 billion or 19 lakh people have been excluded. Justice Ansari, my question to you is, what happens to these people who've been excluded from the list? Where do they go?
You see, those who have not been included, as is being pointed out, they can go and file an appeal in the Foreigners Tribunal. I have no idea what kind of a decision will be rendered, because this is also under great intense debate rather, that the persons who are not very qualified, they are there in the Foreigners Tribunal. Secondly, if a person is declared, let us assume a person is declared to be a foreigner and he is kept in the detention camp which the government has made, then in that case they cannot be kept more than 6 months. Then where will they go? If they are supposed to have come from Bangladesh, if the Bangladesh does not accept, then what will be the fate of all these people, including their children? And it is a human issue.
In fact, speaking a little further on these tribunals that have been constituted under the Foreigners Tribunal Act 1946, as we've been made to understand from the various sources and reports, these tribunals are being headed not necessarily by judges, but sometimes by ordinary lawyers and bureaucrats who perhaps have very little understanding of law. Justice Ansari, what is your take on this?
See, when you are recruiting hundreds of lawyers to preside over a tribunal, I don't know, when you advertise a post for the purpose of filling it up directly from the bar with experience of 10 years or 7 years at the bar, you do not find. There is always vacancy available. Then how will you in this case find, and more so how the civil servants will be able to determine something which is an absolutely judicial work? And thirdly, it is not even open to the public, it is secret. Why should it be a tribunal function in secrecy? We are after all working under this Foreigners Act is an act which was passed by the Britishers at the time when the constitution did not exist. Today we have our own constitution, and under that constitution you have a tribunal which is deciding on the question of my citizenship, and it is being kept secret. No effective and efficient legal assistance is being provided to me.
And therefore, to really crystallize and summarize the discussion so far, the process that has really been undertaken in order to implement the updation of NRC is severely restricted and is under challenge, not just in terms of the tribunals being headed, but also in terms of the issuance of notices and the other like factors. I now proceed and ask you the next question, Justice Ansari, which is on the proposed Citizenship Amendment Bill, which is really one modus of a fast-track citizenship. How do you see this amendment bill and what objective do you see this would achieve?
That will be for the Government of India when it introduces the bill in the Parliament. Why? Because it appears that Government of India wants to give citizenship to those group of people who belong to various religious denomination. The citizenship, though they may not otherwise be Indian citizen, what effect it will have, how it has to be tested is really for the Supreme Court to say, because there is an argument against it, there is an argument in favor also, that if a person, say for instance in Bangladesh, a Hindu, Bengali, is persecuted on the ground of his religion, then where will he go? He has no other place but to come to India. So you give them Indian citizenship. But then such people have to prove, not by law, such people have to prove that they face persecution on the ground of religion, and it is for that reason that they came. And similarly, if any Muslim has come here, obviously he can't claim that I have come for religious persecution.
And therefore, the denial of citizenship really on the ground solely of religion is clearly contrary and violative of Article 15 of the Constitution of India, and therefore dehors the provisions of the Constitution.
It will be very difficult to say at this stage, because we don't really know what the situation is. Had there been a proper NRC update taken place, then we might have been able to guess this. Otherwise, it is hypothetical, and there is no point in entering into hypothetical questions.
Thank you, Justice Ansari. It was such a pleasurable and learning experience interacting with you. Thank you so much.
Thank you very much for giving me an opportunity to express my views. But I will make very clear that we are not talking on the political issues. We are talking entirely on legal issue or constitutional issues. And to my mind, the Supreme Court did not have, I will not say, but at least the prudent demand the Supreme Court ought not to have placed greater importance on the time frame rather than on solving the issue which the country is confronting.
Thank you.